we should reconsider all the court's substantive due process precedents, including Griswold, Lawrence, Obergefell. That means he thinks we should reconsider.
No, that does not.
Whether you got the right access to contraception.
Totally
and
not.
Yes, we should reconsider whether you have the right to marry who you love.
No, it's...
And that's not only the challenge ahead.
Okay, stop it here. I'm not going to make it. We're going to have to do this in 2 parts. Welcome back to the show, bottom of the first hour. I have a piece that's coming out today just specifically on this. He is lying his backside off to you. Biden is lying right now. And here's the whole part of it. So let me explain. They're talking about, you hear this phrase, substantive due process. And you're like, gee, what is that? It sounds like due process. Yeah, it's basically not. It's a bunch of BS with glitter on it is what it is. Substantive due process is not the same as due process. I mean, unless you all are going to go into the legal profession, you don't need to know it. And if you do need to know it, you don't need to be taught by me, a non-lawyer. So basically, what he's touching on here is, let's take this back to Dobbs for a moment, because this is where all of this started. He made these remarks at the ceremony for the non-respect for Marriage Act. It's not about marriage. The whole signing thing that they did yesterday. And he's citing this dictum that Justice Thomas wrote in his concurrence for Dobbs versus Jackson Women's Health Organization. The Dobbs case was the case that overturned Roe v. Wade, because Roe v. Wade was argued stupidly and premised on something that was completely illogical to the whole issue at hand. So in his concurrence in Dobbs, Justice Thomas made mention of substantive due process. And but here's the other thing though, he prefaced what he said with 2 different statements about how he agrees with majority opinion. So, and it was his verbatim. He had said that he agrees, this is not to argue that Dobbs is anything but about abortion. I mean, he actually said, quote, "Nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion." 2 separate times in his concurrence, he says this. The left wanted to use this as a way to say, oh my gosh, Clarence Thomas talking about substantive due process, he's saying that this could be overturned. What he's saying is, if you're going to argue that certain parts of the Constitution cover certain things when there isn't precedent that they do, you're going to get into legal trouble. And this is going to keep happening to you time and time again. I mean, that's the thing. He's not trying to argue to overturn contraception or anything else. He's saying, look, you do not predicate your arguments on clear, solid constitutional footing. And I'm going to tell you something. Number one, he is not the only justice to have said this. Ruth Bader Ginsburg had already said this about Roe v. Wade. And she warned Democrats. She's like, this is not on sure footing. So that's number one. Number two, what Thomas says here in his concurrence is no different from what he has said a million other times. It's not anything different. Substantive due process is an ideological doctrine, and you can easily manipulate it and make it do whatever you want. He had said, quote, "Substantive due process conflicts with textual command and has harmed our country in many ways. And accordingly, we should eliminate it from our jurisprudence at the earliest opportunity." But again, he agreed, and this is what he prefaced his remarks with, that he agrees with the majority's opinion that Dobbs is applicable only to abortion. So the argument that the left is trying to make and fearmonger with is a complete and total lie. They know that you're too damn busy trying to afford Christmas ham this year. You're not going to go sit down. Let me read Justice Thomas's concurrence. And why should you? That's not a mark against you. Your government shouldn't be so ridiculously Rube Goldberg-like that you can't figure something out in a matter of minutes. That goes to show you that government's too damn big. But they know that you're not going to sit down and read all this, so they're just going to gaslight you about it. That is emphatically the opposite of what Thomas said in his concurrence. Completely to the opposite. And he was very bold in putting it in there. And like I said, it's not anything that he's not ever been bold in putting it in other opinions. But he was saying, look, if you're going to argue a case and protect rights, you need to actually base it on provisions of the Constitution that are applicable.